Let's talk a bit about the differences between a company and a social enterprise. Whilst both are set up to trade products or services, the main difference between them is the purpose for doing so. A social enterprise is set up to achieve social and/or environmental goals, which is stated in the governing documents. A company will sell products or services to make a profit for their shareholders, whereas a social enterprise must reinvest at least half of the profits to achieve their goal. A social enterprise must also generate at least half of their income from trading, i.e., selling products or services, rather than relying on grants or donations. When it comes to winding up, a company will distribute the remaining assets among shareholders, whereas a social enterprise will distribute these assets to achieve their goal, for example, by donating to a similarly minded organisation. Overall, whilst both will trade, a social enterprise will do so with the primary benefit of the community in mind, rather than purely profits like a company. You'll need to come up with a name for your company or social enterprise. However, there are some restrictions on these, including that it must not be too similar to an existing company name, trademark, or copyright. You should then display your name on all business stationery, such as order forms, websites, receipts, and invoices. You will also need to think about how you're going to finance your enterprise. For example, financing from your shareholders, grants and donations, and raising capital. Please remember that you cannot donate profits to charity during trading or mention that you will do so in advertising. When you wind up, your company can decide to donate some or all of the profits after it has paid dividends to shareholders, but you must not promote this intent whilst trading. There are a couple of governing documents you'll need to set up your entities. Firstly, the Memorandum of Association. This is an agreement between the founding members to set up the entity. Secondly, the Articles of Association. This is the governing document of the company and will state how the company will be run, their purpose and power, and set out the information on board meetings and directors. When setting up your company, you will need to appoint directors. They will hold a very important role, being responsible for the day-to-day running of the company, which will entail managing finances and making decisions daily.
Under the Companies Act 2006, directors have various duties. These include making sure that they act in the company's best interest, not acting out with their powers granted to them by the company, avoiding any situations where they may have a conflict of interest, and ensuring that they use their own independent judgment to make final decisions. It's important that your director adheres to these duties, as if they don't, there is a potential for penalties to be imposed on them. While directors have the power to make day-to-day decisions on behalf of the company, if you choose to have more than one director, your company articles of association should set out any important decisions which require a majority or unanimous decision of the directors. Such decisions commonly include appointing a new director, changing the company's name, issuing shares in the company, and securing alternative finance. Your Articles of Association should also set out the rules and requirements for a directors' board meeting to be held, such as the minimum number of directors required to attend a meeting before a decision can be made. This is known as a quorum. The money you are going to need to get the company kick-started is called startup capital. As members, you will hold shares in the company, and in order to raise more capital, further shares can be issued, creating additional shareholders. However, it is crucial that a record is kept of all company members in a register, and this should be updated regularly. In the event the company is wound up, there is a legal requirement to give the shareholders the money they are owed, and having an accurate register of members will ensure that the right amount of money is paid to the right people. Also, extra limitations on the amount of share capital that your business can raise will be set centrally by Young Enterprise. Any operating entity that wishes to be economically sustainable in a real-world economy must be aware of any legal obligations imposed upon them and have robust regimes in place to ensure that they comply with these. Your business is no different. After raising capital to get your business off the ground, a bank account will be needed for the company. This will aid in the management of cash flow, invoices, and direct debits of the company. Many businesses will arrange overdrafts and loans with the bank in practice, which accountants will advise on. However, for Young Enterprise, no loans or overdrafts are permitted. Anti-money laundering rules apply to banks focused on the institution knowing their customer. Banks take these checks seriously, as failure to comply can lead to criminal and civil prosecution, as well as commercial and reputational damage. Banking institutions are becoming more proactive in implementing environmental, social, and governance considerations, and this is something you will need to be mindful of for your company. Once the application is approved and the account is set up, the businesses will have to nominate who will have authority to manage the company accounts. This is usually a combination of people who will have different levels of authority to manage the financial affairs of the business. For instance, directors may be required to authorise particularly large payments.